Thank you and welcome everyone. Welcome to the webinar where we are discussing online money gaming bill. And this bill was actually passed on August 22nd. And it's pretty interesting in the way it has been passed, but I'll come to that later. As we all know, online gaming is actually a very big industry. In 2024, it was $3.8 billion industry and employing 200,000 people. This industry now has a law which government says that it is for promotion and regulation of online gaming. Whether it is regulating or strangulating, time will say. We will, in this bill, in this webinar, actually analyze the bill to see what are the issues and what are the problems, which we will look at it. Before we get into the bill, I was very curious to actually understand government's rationale of passing the bill the way they have. First, the bill was passed by cabinet on August 19th. On August 20th, it was introduced in Lok Sabha and passed on the same day without any discussion. On 21st, it was introduced in Rajya Sabha and passed without any discussion. And on 22nd, let me see if I will be louder. On 22nd, the president actually gave also the assent. The bill, which was passed in 4 days without debate, what I understand from industry rumors, took only 72 hours to draft. What is interesting in my view, that a government which permitted this industry to survive and even thrive for over 15 years, in spite of several challenges which this industry went through in different courts, including Supreme Court, and post winning of all the major legal battles, this industry got a lot of institutional investors, including foreign investors. And after 15 years or 15 plus years of surviving, government decided in a very short time frame, maybe from start to finish less than 5 days, to actually regulate, or as I say, strangulate this whole industry. We will see in this webinar, one, the legal challenges which this bill will face when the case is there in the Supreme Court. We will also analyze this bill from 3 perspectives. First, this bill has banned online money gaming, what we call OMG. We will see how that is likely to be challenged and how that's going to be going in future, how that's going to affect the industry. Second is social gaming, and we will see how this law is trying to regulate social gaming and what is going to be the implication on social gaming. Is social gaming going to thrive past the ban on real money gaming, or even social gaming will follow the same death which the real money gaming is following? And then we will also look at the esports, because these are the 3 categories in which the bill actually defines the gaming sector. For doing the analysis, I have my colleagues, Ashish Kabra, who actually leads our dispute resolutions practice based in Singapore. And he is going to talk on the challenges which the bill faces. Then we have Aaron Kamath, who actually leads our TMT and gaming practice, and from Bangalore. And with him, I will discuss, along with him, I will discuss some of the matters or issues which we see in this bill. And then we have Ipsita, who is leader in our tax team based in Delhi, and she will help us go through some of the GST challenges which industry will face. And I am Vaibhav Parik. I lead technology team along with corporate transaction team. I'm based currently in New York, and I and Aaron will actually help you guide through some of the provisions of the bill. With this, let me jump to Aaron first. And Aaron, can you explain a little bit about online gaming bill, right? This is, oh my God, please go ahead.
Sure, Vaibhav, thank you. And oh my God, OMG is the flavor of the bill in terms of regulation. Essentially, the bill categorizes three types of games, you know, esports, online social games, and online money games. So first, we will start with what is actually prohibited, and little later on in the discussion, we will go to what is permitted and where the opportunities in the market lie, right? But first, what is outright prohibited is online money games. Essentially, online money games is any game, irrespective of whether it is a game of skill, a game of chance, which is basically played by a user with the payment of money, with the depositing of money or any other stakes, where there is an expectation of winning, and that winning can again be in money or other stakes, or something with money's worth, right? But basically, it is where money is put in with an expectation of winning, further money or something else which is convertible to money or which can otherwise be purchased as money, right? Interestingly, setting aside potentially 60 to 70 years of jurisprudence on the subject, games of skill versus games of chance, there is no such distinction in online money games which are prohibited. Essentially, what is prohibited? Any offering, operating of the game, but also anyone who is aiding, abetting, inducing the offering or the playing of such online money games. And the act goes one step further, right, to restrict advertising or promotion of online money games, as well as other third parties like banks and fintechs that may facilitate payments towards online money games. So it is quite broad, the umbrella, not only the offering or making available, but anything to do with aiding, abetting, basically helping a gaming operator in their business conducting online money games, and specifically advertising, promoting, or facilitating transactions pertaining to online money games are considered offenses under the act and attract certain fines and including imprisonment with certain penalties, right? This is essentially what is banned. Now, does it apply to Indian parties? Does it apply to foreign players? The answer is both. It applies to operators in India who may, who may offer such online money games. It may it also applies extraterritorially. What does that mean? It applies to offshore operators who may, like I said, do all of these acts, right, of offering online money games to users in India. So there is extraterritorial jurisdiction. And while we go a little further into the discussion on blocking, etc., right, such provisions could apply to offshore non-Indian gaming operators that may operate online money games to users in India. So that is a very important point, which is explicitly clear in the game. So at a broad level, this is what is prohibited above.
Thank you, Aaron. So we have an extraterritorial, not just prohibiting from providing gaming, but also making an offense if you are advertising, you are helping someone advertise, and you are making an offense if you are helping someone make the payment, right? So it's pretty broad in terms of what it is trying to cover. And we'll see the implication a little later on social media gaming also. But Aaron, can you tell us, right, in terms of virtual currency. They say that, other stake also you can't use it. And today, if you really see, a lot of cryptocurrencies, virtual currencies, and other payment systems are being in vogue and being used, whether it is credit points or whether it is something else. So, what is your implication, or what is your thoughts whether this will be covered in the definition of other stake?
It seems very well laid out, right? In the definition, the law doesn't just say money. So the government has seems to have thought through this to say that today's gaming models are such where it is not necessarily money or only money that goes in and which is paid out. So that's why they say money or other stakes put in. Other stakes is basically anything which is equivalent to money or money's worth, and specifically it can include credits, tokens, vouchers, coins, anything similar, real, virtual, which is basically purchased directly or indirectly as long as it pertains to a game. So, what does this mean? Today, where so many models involve an initial purchase, for instance, where you can purchase gold coins, and those gold coins within the game you can use, to stake or to wager, right, with the expectation of winning something. And that something that you could win may also be some kind of tokens, vouchers, things like that, right? So it's a multi-layered approach, but essentially anything of money or money's worth which is going into a game to stake or to wager or to bet, and anything which comes out in terms of a winning, which can be obviously money, but also something else like a token or a point or a voucher or a credit or a coin, any virtual instrument or currency which is equivalent or has money's worth, right? The law is now wide enough to cover all of that within the garb of online money games.
Yeah, that's pretty interesting because today there are a lot of in-gaming purchases and in-gaming, prizes, right? And we will possibly have to see whether this is something which falls into the real money gaming or not, or online money gaming or not. So we will maybe come to that a little later. But before I move to Ashish on constitutionality of this particular law, I want to tell the audience that please, if you have any question, please write in your chat box. We will take it up as we go through the uh, webinar or maybe at the end of it. So please, if you have any questions, keep on typing in the chat boxes. Now, Ashish, over to you. This has actually been challenged at multiple high courts, and now it is gone to Supreme Court. This is going to be looked at in Supreme Court very seriously. What do you think are the challenges which the government is facing on this bill, and what are the chances which industry will possibly factor in for winning?
Thank you, VP. So you, at the beginning of the webinar, you rightly highlighted the curious way in this bill has been sort of passed and converted or enacted into law. Now, there are principally two legs to the constitutionality challenge. Obviously, there are multiple grounds within it, but broadly speaking, from the lens I see it, it's two legs. First, does the parliament have competence to legislate on this matter? This ground essentially is that under our constitution, there are demarcated areas, certain areas which are the exclusive domain of the parliament to legislate on, and certain areas which is the exclusive domain of the state legislatures to make laws on. Within the state list or those areas delineated for the state, specifically, there are provisions for gambling, betting, and then on the gaming side, sports, entertainment, and amusement. So these areas have been specifically under our constitution provided for or given or passed into the exclusive domain of state or where only state is empowered to make laws on it. And therefore, obviously, the first question that arises is the central parliament or the parliament enacting a law regulating gaming, which effectively could be or is falls under the ambit of sports. Is it effectively in substance encroaching upon states' power? And if so, then obviously the law cannot be or the parliament cannot pass the law on that subject. We see that the center may justify their power to pass laws on the basis of certain entries within list 1 of our 7th schedule of our constitution, which enumerates all the areas where the central government or the parliament can legislate on. Within that, there is an entry which covers industries, the control of which by the union is declared by the parliament by law to be expedient in public interest. So they may say that they are regulating an industry here in public interest, and therefore this would come within the scope of their power provided under the list 1 of our 7th schedule of our constitution. However, again, there's a challenge here. If you look at the law closely, what effectively it's regulating is an activity, not an industry. And therefore, to treat that the law is going on to looking at trying to regulate an industry may not be the right approach. So to justify it there may be issues justifying it under this entry. And the other is a broader entry to say whether Parliament has the power to regulate or make laws on any means of communication, which effectively covers electronic communication and therefore a broader subset, or within which we bring in the broader domain of internet. But again, here, the mode of communication is not being regulated. What is being regulated is the online gaming activity. And therefore, again, this would not come in. And if one were to start justifying creation of laws by the parliament on the basis that they have the power to regulate electronic communication and therefore anything in the online domain, it would effectively constitute a serious encroachment on the power of the state to make laws or areas that have been delineated, particularly in the kind of now that we have moved and everything happens online. Surely that kind of a interpretation cannot be taken of what's given under the lists of the delineation provided in our constitution. So obviously this would be the first leg of challenge, whether the parliament has power to legislate. Interestingly, earlier in this year itself, the minister had made a statement in parliament that regulation of these game of skills or online money games is the domain of a state. However, we see a departure from that position now. Equally, since there have been multiple cases in the past where states have come up with their own laws to try and depending on a particular state, to either prohibit or regulate this activity or online money games, which in turn have given rise to various cases before different high courts in the country. And and at least in some of those cases, again, the union was also a party. And at least I am not aware whether the union took a position that this was something that they could make laws on and not the state, and whether the state had jurisdiction or state had the competence to make legislation on this domain. So it would be interesting to see, having taken those positions previously, either in those cases or before the parliament, how the center will now try and justify a shift in their position before the Supreme Court in the ongoing pending challenges. So that's the first leg. The second leg on which the challenge would be is if the parliament indeed has competence to legislate on this matter, then to the extent of games of skill, the prohibition which has been brought in, or the complete prohibition, is this truly a reasonable restriction or not? And within it, obviously, there are multiple ways to look at it, and the court will be weighing up the exercise of, on one hand, it is what the government is saying, that there are certain, say, financial and psychological harms that some of these games may bring, versus, on the other hand, that in the end of the day, these are game of skill. And the fact that there is an entire large set of people, or the entire economy, so to say, that is now functioning, wherein a number of people are employed, a number of businesses that have come up. And therefore, the question will arise when you are weighing up these two interests, where should the balance lie? And is the balance truly towards a complete prohibition of online money games? And at least to that extent, if you see the various judgments which have come from high courts earlier on the issue of constitutionality around prohibition of online game of skills or online money games involving game of skills. There, I think the unanimous position of all high courts has been that an absolute prohibition is definitely not a reasonable restriction. Though the relevant state legislatures do indeed have the power to regulate these areas. So I think that again will be a strong ground, and we'll have to see how center tries to justify this. Maybe they may try and draw a delineation between esports and online social games versus online media, online money games. However, again, merely because you have an online money game, it does not mean that it is still not a game of skill at the end of the day. And if it is a game of skill, it indeed has the protection under Article 19, and therefore, should there be a complete prohibition, again, will be a question will then have to be answered. So those are primarily two legs. There are obviously other sort of finer points within each of these, but broadly, this is the two sort of thrusts that I see of any sort of challenge or the which are currently being heard or will be heard before the Supreme Court.
Thank you, Ashish. Sanjana, I hope this answers your question. And I think Srishti had one more question, which basically says that can it be argued that it's in concurrent list, right? In Article 3, that's what you said, right? List 3. I think you addressed it to some extent, but do you want to add anything on that? Whether it can be in concurrent
So the
list?
idea between any entry within the test, which one has to see that truly or in substance, what is the legislation seeking to achieve? And one, when you look at the substance of the legislation, then under which entry of the various lists provided in our Constitution 7 schedule would it fall under? And the critical aspect of it, why would it not come under entry 34, which is in the state domain, which pertains to sports and which is particularly part of that within there. So that's how we'll probably have to look at it. Then obviously corresponding entries both under list 1 and list 2 will have to be seen to determine whether it can be justified under those entries. And if so, indeed, if it's in the concurrent list, then indeed Parliament would have the power to legislate on it. But equally, then it has to be justified. Why is there a shift in Parliament's position or the centre's position from what they had taken previously? And why would it not come under entry 34 of the state list?
Thank you, Ashish. As we see, right, online money gaming is very critical, very important. But the trend towards it is basically that it will be very heavily regulated, even if it is not online, banned, completely banned. But bigger than online money gaming is the social media gaming and the esports, which is a new category which is being brought in. So we should actually spend more time discussing esports and online social gaming. And this is where I want Aaron, you to tell me what are your thoughts on how esports is going to be regulated and how online social gaming will be regulated.
Absolutely. I mean, even earlier today, the IT minister made a comment, a little separate in light of the the impending data protection law, but he also commented on this that the intent behind banning online money games seems clear with social issues, from depressions to suicides to financial losses to children getting hooked. But one thing the government is clear on is that they want to promote the esports and social gaming ecosystem. And this is where the opportunity lies. This is where we will come to, but business models are evolving, operators are pivoting. So this is essentially the government has come out with clear intent wanting to promote these kind of models, right? So let's first understand what exactly they mean. Both are defined, both are set out with particular criteria which need to be followed to be constituted as such games under the law. Esports are essentially multiplayer games, where there are rules. They are like competitive games between individuals. They can be multiplayer formats. Basically, there is no staking, wagering, or anything of that sort. There can be prize money, which is clear that it needs to be performance-based prize money. And the important point for esports is that they are basically games which are determined by factors such as physical dexterity, mental ability, strategic thinking, and similar skill sets. Essentially, what they're eliminating is games where there is a lot of chance. Basically, you can play multiplayer games, but ultimately a player who has better skill, mental attributes, judgment in the game will, win the game. And, that is essentially what an esport is. As I mentioned, absolutely no putting in wagers, bets, anything of that sort. There can be a registration or a participation fee for the purpose of entering the competition. And as I mentioned, there can be a predetermined performance-based prize winning. So they are very clear to demarcate that, there can be a pay to play, as we call it, which is a standard fee applicable to all who play the game, which goes into the service or the technology, things like that. But there cannot be any betting, wagering, or staking of any money. So that's essentially what an esport is. Now, one important aspect I missed is that an esport also needs to be registered with the National Sports Governance Authority, which is to be set up. And registration of an esport is required for this format to be considered an esport under the law. Now, if it is not, then chances are it will not be considered an esport under this law, even if it meets the other criteria. What does that mean? It means that even if you're doing all of these other elements, physical dexterity, multiplayer events, performance-based prizes, all of that, but if you're not registering it, there could be a risk that the law will not deem it to be an esport, and hence it could fall under an online money game, which is prohibited in the first place, right? So, we'll have to wait and see, but this is likely, the intent, and it should be registered it should meet all the criteria, including registering with the authority for it to be considered an esport. Now, segueing into social gaming. Now, social gaming is, sort of, it's a third category, but it's sort of a exclusion that has been made, to online money games and esports. It's basically a game primarily for recreation, education, entertainment. Um, there there can be a participation fee, which can be through a subscription model or a one-time participation fee. Again, no staking, wagering, or placing of any bets with the expectation of winning. And like I said, they exclude it. So it is not an online money game or an esport. So like I said, it's more of an exclusion to which is any other game. And there are so many models that you can look at, from Ludo to Snakes and Ladders to puzzles to crosswords to chess to all of these, social or casual gaming that you call it, which is either for, entertainment, education, purposes like that. Or general recreation or even skill development. A lot of games today are to develop your mental abilities and reaction time and those kind of things, and these are permitted. Now, the important point is, what if you are not considered a esport or a social game, right? that is where you that is where operators need to be mindful. If you are not meeting all the criteria of an esport, which includes registration, if you're not meeting all the criteria of a social game, there is a risk that you can be classified as an online money game, and then that is a prohibited activity, as we have discussed. Now let's break it down. Now, for example, a social game. Now, social game doesn't expressly permit the offering of any prize money. If you remember, we spoke about esports. Esports allows certain tournament-based, performance-based prize winnings, which are predetermined. For example, 100 players or 50 players may play a multiplayer event, and the top 3 on the leaderboard will win certain categories of prizes, right? Now, online social games, there's no such prizes which are expressly permitted, but you can put money to play, right? So essentially, if there is a prize being offered, then how do you distinguish that the money that you put into play is not a wager or stake with an expectation of winning the prize money, right? Hence, you shouldn't offer prize money. Else, if you offer prize money, you shouldn't take any participation fee, because when these models are deployed, it's going to be very difficult to distinguish, saying that you have charged a participation fee, but that participation fee is not towards just playing the game. And how do you then argue that the user did not have an expectation of winning? Because a user may have an expectation of winning the moment they put in a participation fee, because they expect to win the overall prize, right? So these kind of models have to be looked at. Typically, you can maybe take a position that you can pay a prize, a performance-based prize, if that you're not taking any money to play the game. But if you are, then there should not be any linked, prizes at the end of it. So each model, once this law comes out in the next few weeks, each model is going to be looked at, and accordingly, even gaming operators, for instance, working with fintechs, they will have to discuss their payment models. Fintechs have their obligations under RBI regulations, under banking regulations. The banks have their own obligations in terms of facilitating funds and money flows and transactions. But even under this, they can be penalized. So they will have to. So operators and banks and fintechs will have to work together to show that if there is an e-sport, money being put in is purely a participation fee. If there is a payout, it is purely performance based. If it's an online social game, the money is purely for participation, right? And there is no money coming back in terms of a winning to the user in such cases, right? Else it can be an online money game. So these kind of models, are contemplated, will have to be re-looked at, and also hopefully some clarity on some of the operational points may be brought in, through rules and FAQs that we understand the industry is currently working on.
Thank you, Aaron. I'll take few questions before we dive a little deeper into the point which you were mentioning. I think one question came up which says that would this encroach on state jurisdiction where certain states like Goa are permitting running casinos, right? And Harsha, you are perfectly right. You have 3 states, at least which I know. Goa has casinos, which I don't think will get too much impacted because that's offline and not online, unless the casinos are connected to online and then somehow can get tangled into this particular law. Most of the casinos, if you are just playing on a standalone basis, should not get affected by this law. But you have states like Sikkim and Nagaland, which has actually given license to play online skill games. And those companies which have license and are officially legally operating will get affected, right? In an ideal world, you should have states like Nagaland and Sikkim actually opposing this law, saying that, hey, you are taking away my right. But because those are also governed by ruling party, and it seems that the central government has spoken to some of those states who are getting impacted, and they are not likely to complain. But answer is yes, it is going to affect some of those entities or companies which have been operating in states where it was permitted. Now, with that, let me go to the next point. And while we are going, there are a few more questions, right? There's a question which somebody has raised, which talks about that, the cred and Paytm and phone pay, right? Those provide those kind of games. What will happen to that? And there's another question which somebody has raised, that if he is watching an advertisement which is on online gaming, what will be the implication of that, right? Aaron, can you go a little deeper into some of these newer models which are likely to come up on social media gaming? And, if you can also address some of this question, it will be great.
Sure. Essentially, when we look at what the industry is doing today, a lot of major players have already wound down, online money games in light of the impending introduction of the act and enforcement into law. Now, some of them are pivoting into completely other jurisdictions to start with. A lot of them have now entered other markets. A lot of them are leveraging existing technologies, platforms, employee base in India to support, overseas operations and all of that. A lot of them are going into streaming, into other kinds of media, away from the gaming segment altogether. But staying within the gaming segment, what exactly are players doing? A lot of gaming operators are now offering what we call as free-to-play games. So there is no cash transaction with the user. In some cases, it is loyalty based. It is, just come on the platform, play this game, win some points. Yes, the points you can redeem maybe for some in-app skins, weapons, benefits, features, or maybe in some cases you can redeem that for physical items like a mobile phone or some kind of goods, some kind of products as a price. Now, basically, a lot of them have cut transactions, and we understand that a lot of banks and fintechs are also currently keeping APIs open with such models, to return user deposits and funds and all of that, but are not at this stage facilitating cash transactions for newer kind of models as well, until there is some development and clarity in terms of the law. But a lot of models now are pivoting to free to play, your Ludo, snakes and ladders, puzzles, chess, these kind of social gaming models, where there can be loyalty based points which are issued, to keep customer engagement. Now, how are they revenue generating? Well, obviously not through any cash transaction with a user, but a lot of them are now going into ad supported models. A lot of them, by mere increase, or not necessarily increase, but retaining customer engagement, right? You watch a video before you can play, or ad pop-ups, and that's how platforms are now looking at sustainable models through ad supported games, through in-app purchases. So in-app purchases like skins, features, passes, those kind of things will continue to be allowed because it's an in-app purchase. It's not linked to any expectation of a winning, right? For example, you want to unlock a new avatar, or a costume, or some kind of level in a game or something, that could be permitted. People are also looking into influencer brand integrations. Now people are looking into gamified models. Now, I think one sector, um, not only one, actually a couple of sectors which are bound to benefit a lot from the permissibility of online social games is your education as well as your fitness sectors, because these kind of social games are recreational, educational, and skill development based, right? A lot of education programs can be gamified, a lot of fitness programs can be gamified, right? So this presents new opportunities to existing fitness centers, to a lot of learning platforms, who now can move into gamified models, obviously within the realm of online social games, and not touching the essence of online money games, obviously, like how we discussed. But they can pivot into these models and get the benefits um, under the law, right? So essentially, we're looking at other models which are not necessarily gaming platforms, right? We're looking at, again, e-commerce sites. We're looking at UPI platforms and fintech apps, where they just want to reward you for coming on the platform and doing a recharge, or ordering food, or engaging in quick commerce or something like that. So because of that, because of the transaction, you may order your groceries from a local vendor on the quick commerce app, or you may do a mobile recharge. But as a form of loyalty, they can issue you those points, and those points you can accumulate, or use it for some kind of freebies and stuff like that. So we are seeing now these models, which are still permitted within the realms of social gaming, that now not only gaming operators but larger overall media and e-commerce platforms can pivot to retain their consumer bases, to keep things interesting, to keep customers engaged. So it's a big opportunity for the market that way.
Thank you, Aaron. There are so many questions coming in. I'm not sure we will be able to address all of them, but I'll try to address as many as possible. I think there was one question which says that can an Indian company provide gaming services to non-Indians, right? Would that violate law? The answer really is that, let's assume even if you provide gaming services, first of all, I think it will violate law, but even if it does not, if you're receiving money from them, it's different, but how will you actually make payment to them in terms of prices, right? That's something which will not be prohibited, neither under FEMA nor under this particular act, right? So the point really is, answer is no, to be very honest. Second question which came up was, what about the back offices? Back offices are perfectly fine. They have been operating for ages, and they can continue to operate, not an issue. However, what I want to kind of caution you is that if there is a back office which is there, and if the company is providing online money gaming outside India, they should make sure that they geo-block or otherwise not provide game in India, right? Because that is going to be very critical. Because if they ended up providing to gaming in India, then somewhere the back office guys may sometimes get involved, or the back office can actually get trapped into this. Um, there is a there are several questions. I'll come to that, but let me now move to a situation which Aaron you talked about, and some questions are also there, which is which is in-app purchases and purchases. Some of these fintechs rewarding people to coming into platform, or quick commerce companies coming into platform. Now, all these things need to be scrutinized very carefully, because one, as Aaron said, that's perfectly fine and there should not be any problem. That should actually work. But it's to be very clear that somewhere you are not charging that kind of, for some providing something, you're not charging separately as a price of your, original product, what you are giving, right? So it's not that you may not be charging any subscription money for somebody to play game, and hence you are social media gaming. But if you link it to them buying your product, then sometimes it can be questioned that are you charging them through the price in your product, right? So that's why you need to be very careful on how you design it before you actually go and do it. And same thing goes with in-game app purchases. There's a question which was also asked, and the online money game is so broad, the definition is so broad, that if tomorrow, if you have a social game in which people can do an in-app purchases, right, which somebody can also get through credits which they get through playing games, then it could be argued that these credits which they got are equivalent to money or other stake, because they can be used to do in-app purchases which otherwise is available for cash, right? So basically it is the other stake can be argued. So one needs to be careful. As the law goes, it is very broad today. We hope that the rules comes out, and when the rules come out, they give a lot more clarity. But as the law stands today, just reading it on a standalone basis, it has a very wide impact, and it can actually not just prohibit the online money gaming, but also strangulate the social media gaming. With this, I would want to move to Ashish again. Now, this is something which has been troubling me a lot. Offenses under this law are criminal, are non-bailable. They are wide. They are not just for the online gaming companies, or if it's a companies, then any manager or person who is in charge of it gets covered. They also apply to advertisers, and they also apply to financial service providers who enable financial transaction. All these laws, right, all the offenses, a police officer which is authorized by government can, on suspicion, search or arrest without warrant for any offenses which have committed or about to commit. So which has not been committed but about to commit, or he suspects that he will get committed. And also understand what is an offense. As Aaron mentioned earlier, it is not simply actual money gaming, but even aiding and abetting, right? So if a police officer suspects that you are aiding and abetting someone who has or who is about to commit an offense, right, then he can come and arrest you without any warrant, right? He can come and search your house or your office without any warrant. Now, this, in my mind, is extremely broad power, right? I want Ashish to kind of comment on this. And also when you, Ashish, comment on this, also look at for extraterritorial situation where these companies are actually outside India, what power do government have, especially the blocking power, right? So address those that point also, if you can.
Sure. So obviously, usually we have seen a power of arrest being given without warrant in extreme, in very different situations. Say, for example, TADA, UAPA, and other laws which are linked to serious criminal offenses, uh, where there is threat to life, risk to loss of life, or imminent risk or physical harm being suffered by large sections of public. In those contexts, the police or authorities have been given a power to arrest without warrant or power of search and seizure. We have taken that type of a power, which has been used in such circumstances, and given it and applied it to a situation of online gaming. Now, obviously, in a situation of esports and online social media games. So, obviously, online social games. So, obviously, there is, or this will definitely be another ground or a leg on which the law will be subject to challenge. And I hope that Supreme Court reads into the law certain safeguards for exercise of such power by the authorities, or otherwise, if not strike this law down completely, or at least such power that has been given to the authorities under this law completely. So that's the hope. Let's see what happens. But surely such a draconian power in such a scenario is not at least warranted or reasonable in the hands of the authorities. Particularly if you consider the context, right? Let's say if there is a online money game which is taking place, it is very difficult to compare that to a situation where probably you're looking at, say, a terrorism or a threat of loss of public life altogether. So we will have to see how the courts look at this, but hopefully this is something which is uh, you know uh, which gets watered down or brought down, if not completely sort of struck down.
Thank you, Ashish. Did you also address the blocking portion?
So, blocking is there, VP is also there, but if you see blocking is given in terms of Section 69A of the IT Act. And under Section 69A of the IT Act has previously undergone a challenge already in the Shreya Singhal case, and its constitutionality has been upheld. So, to the extent of blocking, uh, the safeguards or that were read into the law were required to be followed or adhered to, as laid down in the Shreya Singhal judgment, is something that should apply equally here. And therefore, the rules and guidelines which have been introduced under the relevant rules for Section 69A of the IT Act, those will have to be followed, which involves a right of representation even to the intermediaries and those affected. So we hope that the same government will follow those guidelines there. But the power of arrest definitely without warrant is something that is quite jarring.
Thank you. So at least if you are an online or non-Indian, then really the only option which government has to block, and which Ashish mentioned already, there has been safeguards put in there. But if you are in India, and as I was mentioning, right, it is not just someone who is playing games, but or providing games, but also you have advertisement companies as well as the financial services companies. Now let's put ourselves into their shoes, right? They will not be able to determine whether it is a social media gaming or whether it is a real money gaming. Even though social media gaming is permitted and it is fine for someone to provide that particular games, if you are a financial services provider, or if you are an advertising agent, advertising company, right? Would you be willing to take the risk, since you can go to jail without arrest, without arrested without warrant, just on suspicion? Answer is really, I will find it very difficult for any advertisement company or any financial services company to provide service to any gaming company, including social media, social services or social games, right? Unless the rules comes and specifies, gives clarity to these agencies. In absence of that, the way current law stands, I believe that social media gaming companies will not get any support from advertisement or from financial services. Now, if you don't get support from financial services, which means you cannot collect subscription money. If you don't get support from advertisers, that means you cannot collect sponsorship money. In which case, how would you actually make money, right? Even though it's a free to play games, right? So I foresee a lot of challenges on social media gaming companies also. In fact, things which government wanted to promote and regulate, in my mind, the way law currently stands, they will be strangulating the online social media gaming sector too, not just the online money gaming sector. But with this, and I know there are a lot of questions, we are running out of time, so I'm going to come to the most important aspect on tax, which Ipsita, I know I'm coming last to you, but this possibly is going to be the most critical. Can you tell the implications of GST on this particular sector? Can you also address some of the past issues which people uh, were facing, and the Supreme Court case which recently got concluded, though the judgment has not come out, and see how this is going to go.
Yeah, sure. So, I think, like we have been discussing, this sector has seen its fair share of up and down. We discuss the regulatory ups and downs from a tax perspective. Also, this taxation of online gaming has evolved significantly. At least earlier under the GST Act, supply of actionable claim in relation to supplies other than betting, gambling, and lottery were not taxable. So the whole question, the whole controversy which was at the forefront was whether a particular game format qualified as a game of chance or a game of skill. This issue came at the forefront from a tax perspective before the Karnataka High Court in the Gamescraft matter, wherein the Karnataka High Court, while adjudicating upon a rummy format game, held that rummy is, whether played with stakes or without stakes, rummy should be considered to be a game of skill, and therefore GST discharge on the service fee or the platform fee charged by the operator was the correct approach adopted by the operators. What happened post the Karnataka High Court judgment was in October 2023. The GST law was significantly amended to provide for specific tax regime for taxation of online games and online money games for the very first time. This change included a specific introduction of a new valuation rule, which was providing that the value of supply of online gaming would include the value of the specified actionable claim, and also any amount which is paid by the player to the operator for participating in the game. Supply of specified actionable claims, which included actionable claims in relation to online money gaming, was also made taxable, specifically under this new amendment. What happened after this amendment was operators started getting show cause notices with huge demands left, right, and center. Naturally, all these show cause notices were challenged at the respective jurisdictional high courts, and several high courts granted a stay on these notices. And because of the number of show cause notices that started reaching multiple high courts, the Union of India, in fact, requested for a transfer of all these petitions to the Supreme Court, and all these petitions were combined and transferred to the Supreme Court, along with the petition wherein an appeal was filed against the Gamescraft Karnataka High Court judgment. So everything came to be at the level of the Supreme Court of India. The real question which begs importance is what is essentially pending before the Supreme Court, the ruling that we are awaiting. there are 2-3 things that the Supreme Court is going to rule in this ruling. So, the first aspect is there's a challenge on the old valuation rule, the Rule 31A, which has been challenged on the ground of being violative to Article 14 of the Constitution of India. Also because it was considered to conflict with the provisions of the main act. The 2023 amendments have also been challenged before the Supreme Court on the ground that the amendments remove the well-recognized concept between a game of skill and a game of chance. And the scope of the amendment is beyond the GST Act because there is no nexus between the consideration and the supply of services. What has also been challenged before the Supreme Court is also the retrospective applicability of the 2023 amendments, because as soon as these 2023 amendments were passed, while legally they were effective from 1st October 2023, the tax department started sending show cause notices with retrospective effect. So the retrospective applicability has also been challenged before the Supreme Court. The matter carries significant financial implications for the operators and stakeholders, and it will really impact how the liabilities for the period prior to 2025 are impacted. But the crucial point now with this new act is that what happens if the Supreme Court decision is positive or negative one way or the other, because this new act essentially, like we discussed, prohibits all types of online money game. What is now permitted, like we have been discussing, are two types of games, that is esports and online social games. From a GST perspective, what going forward, what operators will have to kind of see is that whether these games come within the ambit of online money gaming under the GST law. Interestingly, while online money gaming has been defined under the new Gaming Act, there has been an existing definition under the GST law. If one were to compare these two definitions very closely, one could argue that the definition under the gaming law is quite broad and the definition under GST law is very narrow, because under the GST law, what is considered as online money gaming is a game where players are depositing money or money's worth with the expectation of winning. However, like we were discussing, in case of online social games, there is no deposit of money or money's worth. It may be a fee which the platform may charge, which may be a subscription fee or a participation fee, but it is not a money or money's worth which is being deposited. So one thing that would have to be analyzed is whether the game format is being qualified as an online money gaming. Why this will be relevant is because there is a mandatory, especially for foreign operators, there is a mandatory requirement to register if a game format comes within the ambit of online money gaming. So for whatever games that are permitted, there has to be a very careful analysis should be done on whether they would qualify as online money gaming under the GST Act or not. The second thing that would be very interesting to see, in case the Supreme Court decision is negative, considering so many companies have already shut shop or have downsized their operations, how will the liability be actually crystallized? Are we looking at tax authorities going behind the directors, seizing assets? How will the tax authorities really recover those demands? Because companies have shut, employees have been fired, businesses have shut. So what will be the impact if the decision is negative? It is a very big question, and how they will actually enforce the decision, we'll have to see if it comes in a negative direction.
Thank you. I think there was just a question which came up. It's saying that going forward, since online money gaming are banned, how will the GST get taxed? You may want to just address that question.
Yeah. So, like I said, while it is banned, one thing that has to be analyzed is whether the game format would be qualified under online money gaming. Irrespective of whether it qualifies within online money gaming or not, there's also a broader definition of online gaming. So whatever fee or platform fee or participation fee that the gaming operator is charging, that will continue to be subject to GST. The old aspect of specified actionable claim, etc., may no longer be applicable, because in the new models which are permitted, there is no actionable claim to begin with. There is no deposit, so therefore there is no claim in debt, and therefore there is no actionable claim. So what would essentially get taxed going forward is only the service fee element, which may be taxed at 18% depending on the game format.
Thank you, Ipsita. I know we are run out of time, but I will take some of the questions, right, and answer. And there is one question from someone who basically says that, look, if you are winning virtual coins, right, from other participants, but coins are non-withdrawable, then how does this fall under the other stakes in the act, right? I think the question, what I understand, is that if you win something, which you need to use it there itself, which is money equivalent, which you are getting it from other participants, right? And other participants are using it by buying it, right? And you are using it itself. How will this be other stake? The answer is the definition of other stake today is so wide that it actually can fall into the definition of other stake, because you are getting something which is money equivalent. It is not material, whether it is actually used in that particular game, or it cannot be, you can redeem it. So even if you cannot redeem it, so you are getting something which is money equivalent, you can fall into the definition of online money gaming. Now, having said it, I suspect that a lot of this particular situation should be addressed in the rules, right? Where, and the FAQ and the rules which are likely to come up in some time, I believe industry is actually working with the government in trying to address some of those issues. So what industry couldn't do during the act, they are trying to do at the times of rules. So hopefully some of these issues will get addressed, but in situation it does not, it can get covered. There was a question which says that watching ads or spinning the wheel, right, to win virtual currency, would it be okay or would it not be okay, right? Answer really is whether you are paying it to spin the wheel, or is it free, right? So you need to look into very detailed situation, right? Detailed features of the act to determine whether it's an online money gaming or it is not. I think simple yes and no will not really suffice, and that also goes. I know, Christina, you have written and you have asked the questions on your app. It's a very specific question for your app, which you will need to examine separately in detail. But the fundamental point is that if it's available on Apple and Google Play Store, right, you are likely to see that Google Play Store and Apple Play Store banning all the gaming apps completely at this point in time, without until there is a lack of clarity of what is permitted and what is not. So that's something which is likely to happen. And also what I want, so there was one question which says that when it is likely to get notified. I think they are waiting for rules to come out and FAQs to come out. So we will see, we at least have a couple of weeks or 2-3 weeks before it gets notified. There are so many questions. I don't think I can take more questions, but if you think, if you really have a question, you should just do a one-on-one email to us, and we will hopefully be able to respond to that. With this, I would like to close, but before I close, I just want to ask the panelists if they want to spend any, if they have any last words which you want to say.
Indeed, Vaibhav. Firstly, thank you everyone for joining in for the discussion today. And clearly from the questions, it was an extremely interactive discussion, so we appreciate that. That said, just as a closing remark, I know there are a lot of questions about FDI. Now, the way the government has brought the law in within a matter of 3 days without any detailed consultation with the industry, and how it actually reflects a change in position from what was there earlier, given the High Court judgments, the intermediary guidelines, and the statements made by various senior functional ministers. There could potentially be also those who are affected by this ban and who foreign investors who had invested in these businesses, depending upon the time at which they invested, they could also explore if their investment is protected by any investment treaty. And if so, what are the recourses available under those treaties for them, given that their business is now, entirely being brought to a standstill over the course of 3 days. So that's just from me. But again, thank you to everyone for joining in.
Thank you. Aaron or Ipsita, last words?
Yeah, no, nothing from my side. I was just going to say that on the FDI bit, even from a FDI perspective, what courts were earlier seeing, because what is prohibited in FDI is FDI in gambling. And again, it went back to the whole discussion on whether it is a game of skill or a game of chance. So even after this law, while effectively, I don't know if investors would actually be interested in making future investments in this sector, but at least for the old investments that have already happened, they were happening on the premise that it is a game of skill and not a game of chance. So nothing else from my side.
Yeah, I'll quickly add one point, right? We've discussed primarily this act and some ancillary points on tax, but from a pure business perspective, there will be, irrespective of whether you're falling into, an OSG or an e-sport, as long as you're not touching the prohibition, doesn't mean that all is kosher. So, for instance, existing consumer protection laws will still apply. What does that mean? Provisions on unfair trade practices, which also govern promotions and certain competitions as well, will continue to apply. Ads have to be compliant with ASCII regulations, which apply to digital ads, right? Influencers, endorsements, misleading ad guidelines, dark patterns. There are regulations on dark patterns. So those things will continue to apply, right? Those will not necessarily, not necessarily, will not get repealed, right? We don't know what exactly may go in terms of the gaming and gambling regulations, but these kind of laws, consumer, advertising, these still have to be considered when deploying these kind of models as well. So just a reminder that those are also important.
Okay. Thank you, everyone. Stay tuned. There is a lot of new developments which are going to happen. And, if there is enough development, we may come with the second version at some point in time. So stay tuned.